Mandarin. Mr. Cheng is a member of the California State Bar, Los Angeles County Bar, and Taiwanese American Lawyers Association. He was the 2008 president of the Arcadia Kiwanis Club. He was also a candidate for the 2010 Arcadia City Council. He has obtained a Bachelor Arts degree in philosophy from the University of California, and he has a JD degree from Southwestern University of School of Law. Boy, with all those credentials, I mean, gee, it's wonderful. And we have the special guest to come and talk to you regarding mediations, or what I believe it is. No, mechanics liens, I'm sorry. So give them a warm
it's always uncomfortable with me lecturing when I hear my bio and I realize that many of you, that's probably the bio of your little pinky toe. So it's an honor to be here. Again, I'm excited. I was actually kind of confused just because I believe I'd given the lecture before, but that doesn't necessarily mean it's a bad thing. I know that a lot of people frequently ask me about mechanics liens, and I actually, after you go through this, for those of you that haven't listened to the lecture before, and I'll try to be quick because I know our time is very short, you'll be able to know really as much as lawyers do, which, believe it or not, lawyers are very familiar with mechanics liens. So it's kind of an interesting area of law. For those of you that have ever evicted a tenant, it's very similar in the sense that it is very strict as it relates to the law, and if you mess up in just one little tiny way, it throws the entire case. Hey, I played basketball with this guy, and then there was, the reason why I haven't been there is because someone kicked me in the liver. Did you know that?
Was that an elbow or what?
No, he took his heel and kicked me in the liver. I've been unable, I just finished a trial on, it was just yesterday, we had final arguments, and the first few days I couldn't, it was just, anyway, all right, so here we go. Let's just begin. How does this work? Oh, okay, all right. So mechanics lien, it's a multi-part lecture. I've told you before that we can go into different areas of law, but it seems like everybody is very interested in mechanics liens. Don't know exactly why, because it's part of a multi-lecture series, but I can be able to tell you that I do know that when you leave the room today, you'll be able to effectuate your interest in mechanics liens and be able to argue it in front of a court. It's really amazing. Here are the parties to a real estate dispute. There are a lot of people. Why learn about mechanics liens? Very quickly, these are just points I've made up before. Highly specialized area of law, many people make mistakes in. I'll have the PowerPoint out to you guys, because I know every time I've lectured on the mechanics liens, I haven't been able to finish it. So, all right. Here's a summary of today's lesson. On any mechanics liens, on any mechanic lien, you need to ask several questions. Is the claimant properly licensed? Is the claimant properly licensed? 2, 20-day preliminary day notice is required of most people. 20-day preliminary day notice is required of most people. 90-90 rule. 90-90 rule. 90 days to file a mechanics lien, 90 days to foreclose. So guess what? Someone comes into my office and says, I'm trying to sell my house. I have a 5-year-old mechanic lien on my property. It was $10,000 or $15,000. There's fines, attorney fees, and now it's $100,000. Based on this law right here, 90 days to file a mechanics lien, 90 days to foreclose. What is your advice? Invalid lien, exactly. 85 to 90% of the liens I see are invalid, meaning that yes, they're on title. Yes, title doesn't want to help you. And absolutely, absolutely, absolutely yes, invalid lien. So for those of you that have a year, this was a year ago, or 2 years ago, or a 3-year ago lien, or you pull up title and you see hundreds of liens over space years, what's your answer? Invalid. Invalid lien, exactly. Therefore, let's continue. This is great. All right, so Here's a typical example. Contractor builds a house for the owner. The contract price is $100,000. The contractor completes the contract in a satisfactory manner, but owner pays only $70,000 because he feels he is unhappy with the outcome. Contractor will now have a mechanics lien right against the property for $30,000, right? That's just the way mechanics liens work. All right, very easy. In case you're confused, mechanics lien is very much like judicial foreclosure of mortgage. So if you understand that, or you understand judicial foreclosure, it follows in a very similar pattern. Now, in a typical construction scenario, you have multiple types of contractors, and it falls under Business and Professions Code 7055, A, B, and specialty. Now, that's different in mechanics lien law. Now, this year they changed the wording just slightly on several of the codes, so I'll have to update it, I just didn't have time. An original contractor works directly with the owner. Yes, that is typically the general contractor, but any person that's considered typically a subcontractor that works directly with the owner is considered an original contractor for purposes of mechanics lien law. Okay, so let's say you have a project and you have a general. Typically the general then hires a whole bunch of subs. But in mechanics liens, if for example you hire a painting contractor and he comes to your property, he works directly with the owner. He is not considered a subcontractor. He's considered an original contractor. If you're able to understand that, then mechanics lien law is very easy for you. So in mechanics lien law, you can have many original contractors and many subs. All right. So here is the initial issue on any mechanics lien law. Those that fail to properly license themselves cannot get compensation under B&P 143 and 7031. So it's obviously fraudulent and unlawful. It's a misdemeanor if you're supposed to have a license and you don't have a license. Now, what is 143? Very easy to remember. So I'm probably going to date myself a little bit. How many of you guys remember beepers? Yeah. All right, so I had a beeper. And back then when I was younger, we had a whole language, a whole alphabet on beepers. And so one day, somebody sent me a text. And I was like, oh, okay. And it was 143. I didn't know what that meant. And then the person got really upset at me. I said, I don't understand. And he said, well, I sent you 143. I said, well, what am I supposed to send back? She said, 1432. I love you too. Now, why is this very important? Because although 143 means I love you, Business and Professions Code 143 does not love people that are unlicensed. Very easy to remember. Okay? So, Business and Professions Code 143 says this: no person engaged in any business or profession for which a license is required, ... may bring or maintain any action, or recover in law or equity in any action in any court of the state for the collection of compensation for the performance of any act. So, people always say this, well, then why are contractors that are quote-unquote unlicensed able to put mechanics liens on property? Well, the county recorder typically or frequently doesn't check. They don't check to see whether the person is licensed or not. It's basically the rubber stamping things. One time I remember I pulled up, it was property litigation, and one of the things that came to me was photocopied in the county recorder a Nike shoebox. They had photocopied the Nike shoebox and put it into the file. Now I thought to myself, why would someone do that? Well, the reason why is they're not there to analyze whether something is proper or not. They're there to execute the documents, get it done as quickly as possible, and get it onto the record so there's no fraud. Hence, Business and Professions Code. Because if the client comes to me and tells me that the person is unlicensed, then under Business and Professions Code 143, presumably the mechanic lien is invalid. And that happens frequently, all right? Let's go one step further. Business and Profession Code 7031 goes one step further, and it says that if you are an unlicensed contractor, not only can you not be able to sue or maintain, essentially defend a lawsuit in court if you're unlicensed, but you must return all the money back. So a person who utilizes the services of an unlicensed contractor may bring an action in any court of competent jurisdiction in this state to recover all compensation paid to the unlicensed contractor for performance of any act or contract. Powerful, powerful area of law. So let's bring it together. A contractor has done a great job at the request of the owner, has brought materials pursuant to the owner's request, and owner is completely happy with the work done on her property. The question is, well, the issue is one night the owner is at home and sees a ghost. The owner gets scared when she realizes it's only her husband. He's not very good looking. Based on the situation, she thinks it's a sign that she should not pay the contractor because the ugly husband hired the contractor. Here's the question. The question is, the owner comes to your office and tells you what happened. You tell the owner, you ask the owner to see if the contractor was licensed or unlicensed. The owner says the contractor was not licensed. Can the owner refuse to pay? Based on what we learned, the answer is yes. And that is not just with contractors, it's anybody that is unlicensed in the state of California. Anyone that is unlicensed in the state of California. Not only is it a misdemeanor, hold on real quick, not only is it a misdemeanor, but it is also a right for you not to pay. And
Questions later, please.
oh, okay, all right.
Let the speakers finish.
Can the contractor sue if not paid? The answer is yes, the contractor can sue, but the contractor is not going to win. Just very quickly, because our time's very short. All right. And the funny thing is, California Supreme Court, I've been in front of the appeals court quite a bit. However, to get in front of the California Supreme Court, to get in front of the Supremes, very difficult because they have to see an issue that they feel relevant for the entire state of California. And this is what they said. Since the contractor was not officially licensed, they had no right to sue for the contract price. The court stated that it would not enforce an illegal bargain or lend its assistance to a party who seeks compensation for an illegal act. So let me give you an example. What's an illegal act? My wife, very upset with me, decides to hire somebody to kill me. She pays $100,000. $100,000 to somebody. The person takes the money, walks away, decides, you know what, I'm not going to kill Paul. I suddenly don't feel right. Can she sue for breach of contract? Of course she could, but it's an illegal contract. She would never be able to win. That's what the California Supreme Court is saying. California Supreme Court is saying they're not going to enforce an illegal bargain. They're not going to enforce an illegal act. It's no different than if you went out and hired a hitman to go kill somebody else, right? And this is very powerful because for many mechanics liens that are filed, that are invalid, right, people don't realize that and they end up paying more than they should. All right, here's another hypothetical. Sally and Jack have been friends for 25 years. Jack knew that Sally did not have a valid contractor's license because Sally was honest and told him. Jack told her he didn't care. He made Sally build him a beautiful house worth $3 million. After building, Jack then told Sally that he would not pay. The question is this. Sally sues Jack. Jack says that Sally does not have a valid license. Sally says that Jack acted fraudulently. Jack did act fraudulently if you think about it, because he knew in advance and accepted her non-licensure. The answer is this. What is the result? The result is another California Supreme Court case that says that regardless of the equities, meaning regardless of how unfair or fair it is, business and professions code bars all actions, however they are characterized, which effectively seek compensation for illegal work. The statutory prohibition operates even when the person for whom work performed knew the contractor was unlicensed. That is very powerful. That means that you can essentially go up to somebody, have them build, do everything for you. They tell you they're unlicensed. They say that they're the quote-unquote handyman. And you say, great, go through this entire house, gut it, and fix every problem that the prior contractor couldn't do, and then refuse to pay. Or ask them to pay you back for all the material costs that you paid them. Very powerful. Very powerful. And that is unfair. That is unfair. All right, so A mechanic lien is a form of security. Like a trust deed or judgment lien, it's an interest in real property which secures the payment of an obligation. What's the result? When a claimant records a mechanic's lien at the county recorder's office, the law assumes that everybody knows there's a claim and stays away from it. And don't they stay away from it if there's a mechanic's lien? They do, right? It's pretty crazy. So the mechanic liens becomes a cloud on title, making it hard for the landowner to sell, lease, or borrow against the property. So what is a cloud on title? I have a friend, his name's David. I think I'm his only friend. You want me to tell you why? Because every single time you go to David, hey David, how are you? Fine. Hey David, so how's life? Fine. Do you have somebody to introduce to me? I'm really lonely. And you know, those are the type of friends that sap all the life out of you. You know what I'm talking about? You're very happy, you meet him, and then you walk away and you're like, man, I'm not feeling very good, right? Do you know that we're pretty much on this earth only about 27,500 days? And after you meet him, you're not feeling very good, right? You're not feeling very good. That's a cloud on title. That's a cloud on title. Just like everybody stays away from David, subsequently, everybody stays away from property that have clouds on title. So it's very easy to kind of think about it like that. It's very depressing. Everybody looks at it. It's a bad word. Nobody wants to mention David. Hey, you want to go? Hey, David's going to come. That's okay. Maybe another day, right? So that's how a cloud on title is. Why? Why is there mechanic's lien? The reason why is because a property owner shouldn't get the benefit of improvement unless he pays. If you think about it, it is a very fair area of law. Other examples are a party can't breach a contract and then demand the other side to perform the contract. A car buyer can't keep a property if they don't pay. You can't keep a house if you don't pay a mortgage. So it's this type of equity, being fair about things. However, does it give rise to injustice? The answer is absolutely. Why does it give rise to injustice? Because many property owners come to you and they say, I've already paid the contractor, but the contractor didn't pay the sub, and now the sub is coming after me. So that's the unfairness that occurs with mechanics liens. Nobody should get something for nothing, but many times the owner feels like they're left holding the bag. All right, so what is the middle ground? It's not one-sided. What is the middle ground? The middle ground is the policy of the law is to discourage clouds on title. The law doesn't want you to put a cloud on title because clouds on title basically hampers people's use of their property. So the middle ground is, in order to prevent unjust actions, they require strict statutory compliance. What that means is if the person that wants to get a mechanic lien does not follow the law carefully, the mechanic lien is usually invalid. Now, how many of you have evicted a tenant before? How many of you have failed? I have. And I remember that when I was evicting the tenant, I told the property owner on a residential property, you know what, we can't be able to estimate this. We can't estimate the amount that's owed. They said, no problem. We're off by $100, $100. And I said, I have a really bad feeling about this. The law is very strict. Even if you're off by $100 on the amount that's owed, the judge is going to throw out the case. You got to redo it again. I remember the property owner saying to me, you know what, there's no way a judge would do that for $100 when they owe me money. And we actually lost the case at trial, right? We lost the case at trial because basically the property owner got up and it was $100 less. And they were able to show that. That's how mechanics liens are. They're very, very strict. If you do one thing in the wrong way, it's an invalid lien. So the property owners that come to you with liens that are 1 year or more, typically, they are invalid because the law is Business and Professions Code 143 and 7031, 20-90-90, and then we're going to go over the 20-90-90. Here's the summary of how it works. So the the licensure issue we're going to push to the side. Now let's talk about 20-90-90. There's a 20-day preliminary notice required of many parties that work on the property. Then you have 90 days, typically the general rule is 90 days to file a mechanics lien at the county recorder's office, 90 days. And then once recorded, it creates a cloud on title. Then you must foreclose in 90 days. You must foreclose in 90 days on that mechanics lien that you filed in 90 days. So you have 20, 90, 90. So on your left hand, you have 1437031 Business and Professions Code. In your right hand, you have 20-day preliminary day notice, 90 days to file, 90 days to foreclose. Who may claim on mechanic lien? Essentially, everybody and anybody. It's a very broad statute. Many people can claim on mechanic lien. How much time do I have? 5 more minutes? Okay. All right, so I need that. All right, so a person is entitled to the benefits of the mechanic lien if they contribute to the improvement of the property at the request of the owner with the intention to improve. Let's bring it together. General contractor does a remodeling job at the owner's driveway. The general contractor gives subcontractor, a paving contractor, the right to do the job. The subcontractor paved the wrong driveway on another property of X. Right? The question is this: does the subcontractor have a right against X's property because he improved X's property? And the answer is no. The subcontractor would not acquire any right to X because sub did not perform the repaving at the request of X or X's agent. Do you understand? So there's a property. The subcontractor didn't go to this property but went to this property. This guy doesn't want to pay the sub, although he got a free driveway. The answer is, can he sue? I mean, can he be able to get a mechanics lien or foreclose on this guy? And the answer is no. All right. Definition of agent, extremely broad. Anybody can be your agent. All right, very, very, very broad. And I'm rushing through this because we do only have 5 minutes. So here are the time limits. A mechanic lien is enforced by giving proper notice, filing a lien, foreclosing a lien, notify, file, foreclose. Notify, file, foreclose. This, I believe this code changed. The rules are all the same, but the numbers all kind of change. So the 20-day preliminary day notice, it's a fatal lien. It puts everybody on notice that they have a right to a mechanic lien if not paid. Who has to give the 20-day preliminary day notice? Anybody except the original contractor. So if you are a sub, you're required to give a 20-day preliminary day notice. So let me put a hypo out to you. A lot of people come to me and they say, I have a $15,000 mechanic lien on my property. They want $100,000 for attorney fees, fines, costs, etc. And I don't really know what to do. I said, who is this person? They said, I don't know who this person is. I said, well, why don't you know? They said, I really don't know. I just hired a general and the general hired a sub. One of the areas of attack would be, did you get a 20-day preliminary day notice? Because every sub is required to give the property owner, say, hello, I'm here, right? If there's a problem, I'm going to file. All right. So who gets the notice? Essentially everybody. And the law now is even broader. All right, but I didn't put it in there. But it's essentially owner, prime contractor, construction lender. Remember, if the sub is dealing directly with the owner for mechanics lien, they're not a sub. They're an original contractor. So any contractor that works directly with the owner is an original contractor that does not need to give the 20-day notice. Now, okay, we're getting there, guys. So you just got to give it, all right? Oh boy, this is crazy. All right, the law requires mechanic lien to be filed in 90 days. 90 days. If you don't file in 90 days, it lapses and it's over, okay? And so that's one of the things. A lot of contractors file it after the 90 days. They do, because the county recorder isn't going to stop them. So that's another area of attack. What is a notice of completion? A notice of completion cuts down the time of the 90 days to file, and it puts a shorter limitation on when people can file for mechanic lien. The notice of completion must be given. It must be given to anybody that gives a 20-day notice to you, and it now cuts down the time to 30 days and 60 days. Okay, guys, we don't have enough time. Let me kind of explain this. It's actually not hard. It's actually harder if I spend too much time on the slides. You got 90 days to foreclose, 90 days to file a mechanics lien, 90 days to foreclose. All right, it's literally that simple.
There are ways to be able to cut down the 90 days and make it a little bit shorter, but I just want you guys to remember the 20-90-90. Now, Nancy, who is awesome, the question is, why can't she wipe out? Why can't she wipe out the cloud on title, right? Shouldn't title be able to do it? Because the only way to wipe out a cloud on title is to go through court, all right? So only a court can do that. Nancy, while in many ways, and I'm sure you guys feel this, she's almost like kind of godlike. She does so many things and changes people's lives all over the place. One of the few things she can't do is to be able to remove a cloud on title. That's just a reality. The law says that once you remove a cloud on title, it's extinguished, meaning that person can never put it on again. Now, can there be a mechanic lien years and years down the line? The answer is there are exceptions, meaning that if you don't go in to wipe it out or extinguish the lien, then they can continue to renew the lien. Do people renew the lien? Sometimes they do. Sometimes they do, but many times they do not. So what ends up happening is you have a lien that's 5 years old, or 3 years old, or sometimes 10 years old. And the property owner doesn't know what to do. And title rightfully says, you need to go hire a lawyer. Well, the person doesn't want to. But I do want you to know this, a cloud on title that is extinguished can never come back, but if it's not extinguished, the person can renew. But typically they do not. I don't know if that was the question that was going to be brought up.
Somewhere close.
Somewhere close, okay. So if you guys remember that, I can be able to tell you, you know more than what 99% of attorneys know out there, believe it or not. You go up to an attorney right now and you say, tell me about mechanics liens, what are the deadlines? He'll be like, well, let me do a little bit of research and I'll get back to you, right? The reality is the law is very simple. 20 days if you are a sub. You have to give the notice, all right? 90 days to file, 90 days to foreclose. If you don't do the timeline, you can extinguish the lien. There is one last issue I wanted to share. I always kind of consider this kind of a rock star type of law, meaning that you will be just a star in your client's eyes if you listen to me on this area. The law basically says that if there's a dispute on a lien, and you got to get the lien done, wiped out, but you really don't have time. You really don't have time. The law allows you to put 1.5 the amount of the dispute in court, and the lien is gone. So literally, you walk into court, let's say it's $10,000, with a $15,000 check, or cashier's check or whatever, and you say, Your Honor, I want this wiped out. Instantly, it's done. Instantly, it's done. And then you can be able to dispute that later. Why is that important to you? Because the client comes to you and says, I got to get this mortgage done. I need this mortgage, the rates are good, I need it in 3 days. You hire an attorney, you interview an attorney, you file a lawsuit in court, you do all of that, it's gonna take more than 3 days, right? So that's a rock star type of law, meaning that you can just tell the client, you know what, no problem. I'm not gonna charge you, let's walk down to court, give me a check for 1.5 times the amount of the dispute, right? Because they're asking now for $100,000. But the mechanic lien is maybe $10,000 or less. Typically these mechanic liens are not huge. Commercial properties, they are huge, but typically they're very small. It's these quote unquote penalties that the contractor puts on and the attorney puts on that balloons it up to $100,000. Okay? So here's to review. Business and Professions Code 143 and 7031. 143 does not allow a person to be able to effectuate any rights if they are unlicensed. 7031 allows you to get back all of your money that you have paid an unlicensed contractor for anything. In this hand, you have 20-day preliminary day notice, 90 days to file a mechanics lien, 90 days to foreclose. The timeline can actually be shorter, I just want you to know, right? And you need to go into court, extinguish the lien, it will no longer come back. If you don't do it, they can continue to renew over and over. Do we kind of make the cutoff? Is it 9:15?
Yes.
Okay.
You did very
Okay, now, one last